Okay, guys, we made it to our final chapter, which will talk about law and ethics in the workplace. Especially these days, managers have to think about all of the legal repercussions when firing or disciplining their employees. And on the flip side, you as an employee need to know what your legal rights are as well, right? So in employment, the employer is the person or business that is providing and paying for any work that is performed. The employee is whoever is hired by this person or business to do that work and get paid. Wages refers to an hourly rate of pay, and salary refers to payment given on like a yearly basis, typically. Employees are covered by a lot of federal, state, and local laws that go over insurance and pension benefits, workplace safety requirements, and protections from discrimination. There are several different types of employees, and the meaning of each one carries different benefits under these laws. So we have a regular employee, which is also called a common law employee. They have to have continuing relationship with the employer. Excuse me, which means it doesn't have to be every day, but like an agreed upon time, like X amount of days each month. A full-time employee is someone that works 30 hours a week or more, while a part-time employee is 30 hours or less each week. A leased excuse me, or a temporary employee is someone that goes through an agency or a firm and is assigned to work at the business, usually for a certain time frame, for things like if one of their employees out on maternity leave, or if they need extra employees just to finish a certain project or something like that. An independent contractor is not an actual employee for the company. They are contracted to do certain work. So the employer has no control over the means, manner, and method of completing the work. The employer has that control over a regular employee, not a contracted employee. And also the employer doesn't withhold taxes for them, so they have to pay their taxes at the end of the year. A statutory employee is not an employee, but the employer has to withhold taxes for them. So this would be like delivery drivers, life insurance agents, traveling salespeople, things like that. Okay, so the reason this classification is important is because all of your benefits and legal protections and everything depend on what type of employee you are. The Immigration Reform and Control Act made it to where employers have to verify the identity and employment authorization of every employee that's hired through the use of the I-9 form that you have to fill out whenever you do get hired. So on this, you have to fill out your name, address, date of birth, social, whether you're a citizen of the U.S., all those kinds of things. Some of y'all have probably filled one of these out before. They can also use the E-Verify program, which lets them compare the employee's I-9 form against a database to make sure the person is really a citizen with a valid social security number. Okay, so you do have rights as an employee, and it's also a good thing to be aware of if you are ever supervising employees to make sure you never do something that would violate their rights. There are over 25 federal laws in addressing employee rights, and we're going to go over just a few of them. Traditionally, all employees were considered at will, which means the employer can hire, fire, and demote employees however they want, and that the employee can quit if they want, as long as there's no contract. So if you are an at-will employee, your employer can fire or demote you for no reason at all, as long as it doesn't break the law. So basically, all of the control rests with the employer. They had control over what hours you worked, how much you made. There were children under the age of 18 working like 16-hour days, which is obviously not allowed anymore. You could get hurt at work and have to fend for yourself. You could be fired because of your religion or your race, your gender, your personality. Okay, it was hard as an employee. So whenever it started to become more public knowledge of how some employees were being treated, the American public was pretty shocked and started to demand some changes to protect employees more, which has happened all in the last 100 years or so. Labor unions started to become a thing, which is groups of employees like joining together to protect their jobs, work towards like improvements in their working conditions, and kind of create like a formal way to bring these demands to the employer. Employers didn't really react greatly to this, obviously. So Congress passed the National Labor Relations Act, which gives employees the right to organize in these unions and bargain with their employers, and also the right to go on strike and form picket lines, which is exactly what you would think, people standing at the entrance to the work site, like holding signs. Congress also enacted several civil rights laws to protect employees from any sort of discrimination. The Civil Rights Act of 1964 bans discrimination based on race, religion, gender, or national origin. The Equal Pay Act prevents an employer from paying one employee more than another that is doing the same role, okay, the exact same role, just based on their gender. The Age Discrimination in Employment Act bans discrimination against people that are 40 years old or older. And then we also have laws that protect employee safety and security. So OSHA, the Occupational Safety and Health Act, sets mandatory safety standards for all employees in certain industries, which I'm sure some of y'all at least know at least one person that works in a plant, being where we live. So they all have to follow these OSHA regulations. The Work Adjustment and Retraining Notification Act requires employers to give at least a 60-day notice before closing their offices or laying off people, so that they have some time to try to find a new job. And then the Family and Medical Leave Act, or FMLA, requires employees to offer their requires employers to offer their employees up to 12 weeks of leave during a year period for having a child, or adopting a child, or any sort of serious health condition, like if you need to take care of a spouse or a child. Now, this does not require them to pay you during that time off. And so that's definitely something to look for when you are finding a job. If they give you paid time off, paid like maternity or paternity leave, or if it's just you're having to take off this time and get no paycheck during it. And there's a lot of others. These are just the big ones, okay? Pretty much every private employer, any employment agencies, and all labor organizations in the U.S. are affected by Title VII of the Civil Rights Act and its amendments, the Equal Employment Act, and the Civil Rights Act of 1991. These acts all protect employees from any sort of discrimination, gender, race, marital status, if you have a disability, your age, genetic information, okay, throughout every stage of employment: hiring, deciding compensation, training, and firing. They set these standards to require fair treatment for everyone. And we're going to talk a little bit about each of these. Let's see. All right, so sex discrimination is any sort of discrimination based on your gender and marital status. This can take the form of unequal pay for the same work, sexual harassment, being discriminated against because you're pregnant or because you're trying to take leave to have a baby. So the laws are there to prevent employers from hiring, promoting, firing, or anything based on gender. Wage inequalities between genders are addressed by Title VII, the Equal Pay Act, and the Fair Labor Standards Act. All three laws, excuse me, apply to jobs that are considered substantially equal, meaning they're performed under similar conditions and require the same skill set or effort or responsibility. Wage differences are allowed when there's a legitimate seniority system or merit system or something in place that measures quantity or quality of your work. For example, if a male is hired to be a lab technician and then 5 years later a female is hired to do the same exact job, the male is going to make more money just because they've been there longer and have gotten a pay raise probably each year. So that would not be an example of sex discrimination or wage inequality. But if a male and a female are hired at the same time to do the exact same job, but the male's making more money, this would be sex discrimination. Sexual harassment is any unwelcome sexual advances, requests for sexual favors, or any sort of verbal or physical sexual conduct that is made in exchange for some sort of job benefit, like a promotion, or to, if you want to keep working here, you have to do this. A hostile work environment means the unwanted sexual conduct has to be severe enough to change the terms or conditions of employment. So this would include like sharing sexually explicit photos, making sex-related or gender-demeaning jokes, or even repeatedly asking someone to go on a date with them when they're clearly not interested. So typically, for it to be considered a hostile work environment, it has to be more than just one instance, like over and over again, unfortunately. So employers have to develop policies to try to prevent or eliminate sexual harassment, which usually includes investigating any complaints right away and taking appropriate actions. Most companies require you to do some sort of sexual harassment or sex discrimination training when you're hired. Some of you may have done those before. Another type of sexual discrimination involved childbirth leave or pregnancy-related conditions. So this was addressed through the Pregnancy Discrimination Act. And we already talked about FMLA, but this does apply to both men and women. And again, it's not required to be paid. In my experience, I've worked for companies that give, like 6 to 8 weeks of paid leave. I've worked for a company that doesn't give any paid leave. So it just depends. All right, next is racial, religious, and national origin discrimination, which is protected under Title VII of the Civil Rights Act. The act states characteristics of race such as skin color, hair texture, or certain facial features cannot be used by an employer to consider job applicants or current employees in any stage of employment, meaning you cannot make any employment decisions based on these things. This type of discrimination can take many forms, including harassment, slurs or jokes, offensive conduct, or conduct, or comments about someone's race. Okay, religious discrimination is also included in Title VII, making it illegal to make employment decisions based on someone's religion or faith. Also, that employers have to make reasonable accommodations for things such as, not forcing them to work on a day of worship unless doing so causes undue hardship to the company. Moral and ethical beliefs are also included in this. And then discrimination based on national origin is any discrimination based on someone's birthplace, their ancestry, culture, or linguistic characteristics. So this would be any discrimination like based on someone's accent or using racial slurs. um, an employer can require fluency in English, though, if speaking English is required in order to conduct business. The Immigration Reform and Control Act prohibits discrimination based on whether the person is or is not a U.S. citizen. Okay, next we have the Age Discrimination in Employment Act, which protects employees that are 40 years old and up from being discriminated against during the hiring or firing process. It is illegal to put an age preference in a job listing, but you can't use it as a deciding factor in hiring or firing someone unless it is a bona fide qualification, meaning it is absolutely necessary to be a certain age to operate something properly. Excuse me. The Older Works Benefit Protection Act bars discrimination in benefits because of a person's age. So benefits meaning insurance and stuff. It also sets requirements for employers that offer early retirement. It has to be in writing. You have to provide the employee with enough time to consider the offer and enough time to seek counsel. And there are more requirements where the program, like if there's mass terminations, like big layoffs. There are two federal laws that talk about disability discrimination, the Rehabilitation Act and the Americans with Disabilities Act, or ADA. Both of these apply to employees, job applicants, customers, or visitors to any business that serves the public. So this is to protect employees or job applicants based on disability, even if there's just a perception of a disability, or if there's a past record of some sort of illness that has been cured or is in remission. Okay. There's a 3-step process to see whether the ADA law applies to a situation. Sorry, my face was so blown out because it's getting dark outside. Let me lower the brightness on here. All right, 3-step process. First, the employer has to determine if the person in question is qualified for a position, meaning do they have the skills or level of education or license needed for the job? Can they perform all of the essential functions of the job? If the person cannot prove that they meet all of these job requirements to perform the job, then the ADA evaluation process ends right there. If they determine the person is qualified, then the employer has to determine if the person has a disability, which would be a physical or mental impairment that would limit a major life activity of the person. Okay. And thirdly, and probably the most challenging, is determining what reasonable accommodations can be made for a qualified individual with a disability without causing undue hardship to the employer. So a reasonable accommodation is any change in the work environment or in the way things are typically done that helps this qualified person that has a disability to do the job and have this equal employment opportunity. So this would include removing any workplace barriers, whether it's physical or procedural, that would prevent this person from doing the job. Okay, so like if the person's in a wheelchair, they need to be able to have access to their desk from the door. The desk has to be able to accommodate the wheelchair, things like that. The employer has to pay for and provide these accommodations. So because of that, they are allowed to consider if these accommodations would cause undue hardship on them, meaning would it cost, a crazy amount of money, or really impact the flow of work for the business. So examples of reasonable accommodations would be supplying or altering office equipment, relocating a job within the office, like to make it wheelchair accessible, telecommuting, obtaining a reader or interpreter service, relocating the person to another vacant position that they are qualified for and they can do. Okay. Reasonable accommodations would not include personal use items like hearing aids, or glasses. Okay. It would have to be along the lines of the things I mentioned. Discrimination based on genetic information is, again, a newer thing because of all the genetic information out there, from medical research and the Human Genome Project. HIPAA does address this a little bit, especially when it comes to insurance companies not being able to use someone having a gene for a possible illness in the future against them, right? They can't use that against you in your health insurance coverage. The Genetic Information Non-Discrimination Act, or GINA, in 2008 also protects against misuse of genetic information from both insurance companies and employer. So it prohibits the use of genetic information for these things here. You can pause this video, read each of these to yourself. Okay, so on top of the anti-discrimination laws, employees also have workplace protections under laws and regulations governing health, safety. Oh, sorry, guys. Okay. Where was I? Health, safety, hours, pay, and conditions of the workplace. So these laws prohibit certain practices from happening in the workplace and provide entitlements to certain conditions or treatment in the workplace. So like we talked about before, OSHA is under the U.S. Department of Labor and enforces safety precautions for almost every private employer in the U.S. Most states have their own OSHA-like laws and regulations as well. OSHA requires that employers have health and safety programs that focus on their job-specific hazards in their workplace. Okay. Here at the bottom, it says the things that have to be included. So go ahead and read those as well. The Federal Labor Standards Act protects employees from having to work too many hours and against substandard wages, like getting paid below, the industry standard. So this act establishes the minimum wage and sets all of the overtime provisions. There are some exempt employees that are exempt from the minimum wage and the maximum hour provisions if they're paid a salary instead of an hourly wage. And basically, typically they'll have like a managerial role and they can fire and hire other employees. The Equal Pay Act also provides wage protections for people that do like the same or very similar jobs, right? The Employee Retirement Income Security Act addresses pensions and benefit plans and establishes the minimum standards for receiving a pension and certain benefits. It bars discriminatory treatment of people that are trying to use their benefits. Now, it does not require employers to have a pension or a welfare plan. It just regulates employers that do have them. The National Labor Relations Board establishes fair collective bargaining procedures and identifies unfair labor practices. So when all of these unions started to become a big thing to protect employees from an employer, it kind of went a little overboard. So the federal government had to enact this to protect the employer, and even the union members from the unions. Okay. Workers' compensation is a program that replaces income and helps with medical expenses to employers that are injured, or develop an illness or die because of their job. It also protects the employers from being sued by the employee because of something like that happening. So this money comes from the employer, who pays into it on a weekly or monthly basis. And then it's administered by the state in the event of someone getting sick or injured on the job. Federal workers are covered by a federal law. Okay. Unemployment insurance is a program that lets you still receive your regular income if you lose your job, like if you were fired. You cannot qualify for this if you quit. This only if you're fired. This is funded through a tax that the employer pays, and there are strict rules for filing a claim and qualifying for this. There are limited protections on employee privacy. Things like, can an employer do drug tests or lie detector tests, or monitor their employees' emails or phone calls? So this one's tough because, as an employee, you feel like you should have this right to privacy. But the employer feels like they have an interest in what's happening in their workplace, and want to make sure that it's safe and harassment-free environment. Okay, so that's a tough one. All right, social media is becoming a really big issue in employment law. Generally, what you post on social media is protected under free speech, generally. And really, it depends on the employer and if they're looking at their employees' social media. Some monitor it at all times as part of their risk management program. Some don't monitor it at all. And some probably only do if, something you post is brought to their attention. Like someone's like, did you see what so-and-so posted? As a general rule, most employers will look at your social media to make sure that your online image complies with all of the anti-discrimination laws. And I'm sure y'all have seen so many cases lately of people getting fired because of something they posted on social media. Having been in a role where I hired employees, I can say for a fact that hiring managers will look at your social media before hiring you. So it's in your best interest to either be private or don't put anything, like have your profile private, or don't put anything out there that could be held against you in terms of getting a job. Employers do have a duty to address any discriminatory or harassing conduct that happens on social media that can have a bearing on the workplace. Most places now do have social media policies and procedures that'll say what's prohibited, such as, obviously not disclosing protected health information, or posting pictures of a patient without their consent. But it probably has a long list of things on there as well. Okay, so last slide here. Ethics in the workplace is usually in the form of codes of conduct and programs that take these values in the codes of ethics and just turn it into policies and procedures. Excuse me. Codes of conduct are basically just codes of ethics. Those written, I think we talked about this in one of the first chapters, those written lists of a profession's values and standards of conduct. So the example is an organization that values diversity in the workplace will align its policies and procedures to match this value and hire accordingly. Also, employers can create training programs to make sure their employees have a good understanding of what their values and codes of ethics are. Employers will also probably use whether or not you're reflecting these values and ethics as part of your performance appraisal. Okay, and if they're not, they should. And that is all I have for you, and that is the end of this class. So let me know if y'all have any questions, and if not, good luck on the final.